All right. Good evening, everyone, and welcome to the State Bar of Montana's Citizen Law School. My name is Brenda Waller. I am a member of the Law Related Education Committee that is helping put together these programs and will be your host for tonight. Our speaker tonight is Sarah Berg, and she will be talking on the topic of family law. Sarah is a family law attorney in the Helena office of Laird Cowley, which also has offices in Missoula, and she has been practicing for over 24 years. She covers all aspects of family law and mediation. She is a graduate of the law school at the University of Montana and has been in Helena for quite a number of years. Tonight, we will have the availability for you to ask questions. And what you will want to do is, rather than using the chat function, please use the Q&A button. And I will be monitoring that and let Sarah know if there are questions. She said that if we do want to have some interactive discussions, if I see questions in the chat, I will interrupt her and say, we have a question. And so feel free to join in at any time. With that, I'll turn the program over to Sarah. Thank you.
Thanks, Brenda. Good evening, everyone, and I hope you're having a nice night, and thanks for being here to joining us for this presentation. As Brenda said, I would welcome any sort of interaction. This is my third year presenting on family law here for the Citizens Law School. And I'm each year struck anew with how disconcerting it is to speak, do a presentation when the only person that you can see is yourself and the only person you can hear is yourself. So I would very much like to hear from all of you. Please, there's no kind of flow that will be interrupted. So if you have a question or you have a thought, or just throw it in the Q&A. Brenda, as most of you know, is also a very experienced family lawyer, so I welcome her input as well. But obviously the design here is to find ways to get information to you. So if there's questions that you have, please don't hesitate to interrupt and ask, and I'm happy to answer if I know the answer. Family law is an umbrella term that we use to cover lots of different things. Different areas of law often fall under it. Sometimes family law can be criminal in nature. I mean, all of us that have practiced family law have had cases where partner family member assault or temporary orders of protection are part of what we're dealing with. It can involve things like common law marriage or adoption or surrogacy or prenuptial agreements or antenuptial agreements, or, like Brenda mentioned, mediation. Lots of us family lawyers mediate in addition to practicing law as attorneys. But I think it's generally safe to say that for those of us that are in private practice like me, practicing family law, most of what we're dealing with is divorce, dissolution, and parenting. Most of the time, the parenting being a component of that dissolution. And so that's the bulk of what I'm going to talk about tonight, is just kind of divorce from start to finish. When you have a normal civil divorce process, or normal is not the right word, typical civil divorce process where you're dividing up debts and assets and arranging for parenting for kiddos. So family law begins when you're hiring an attorney. It begins with an initial consultation. The client will reach out and we do a conflict check to make sure that we can proceed with meeting with the client. And if that's clear, we sit down and have a meeting with the client and talk to them a little bit about what the process looks like. Kind of get a sense of what they're looking for and the schedule on which they're looking for it to happen, and determine if you're the right fit for them. And then once you kind of determine that you're that right fit, you proceed to talk to them about what the process looks like. And so that's how I'm kind of approaching this presentation, is like it were an initial consultation. So oftentimes what I'm talking about here is what I would be talking about with a client that's coming in my office and talking to me for the first time, maybe, about the idea of divorcing their spouse or figuring out a parenting arrangement for their kids. So kind of just taking them again from point A of being married and not wanting to be married to point B, which is being divorced with your assets and debts divided and your kiddos with a parenting plan. And so that's kind of the loose order of events that I'm going to try to walk us through here tonight in the next hour. Hopefully we can get through it all. I generally talk pretty fast, so please feel free to, again, ask some questions just in case we have some extra time to fill. What I tell clients when we meet for the first time is when you get divorced, you're essentially dividing up two things. You're dividing up your stuff, right? So your debts and your assets, your tangible personal property, and you're dividing up the parenting time that you have with your kids. The way that you divide up stuff, if you can make the agreement without having the court make the decision, is you and your soon-to-be ex-spouse eventually enter into what's called a property settlement agreement, which is a contract that says, here's what we've got, and here's how we've decided to divide it up. You get this, and I get this. With kids, if you can reach an agreement, again, without the court having to make the decision for you, you would enter into similarly a contract with the other parent of your children, called a stipulated parenting plan, where you say, we've got these kids and we're their parents, and we're going to put them on this residential schedule, so where they sleep at night. This is what we're going to do for child support, and here's how we're going to handle health insurance. And those are the two big things that have to happen when we're getting, again, from point A to point B, is we're going to try to generate a property settlement agreement to divide up debts and assets. And we're going to try to come up with a parenting plan to, amongst other things, handle residential schedule, health insurance, and child support for kids. So the vast majority of family law cases, believe it or not, are actually resolved without the judge having to make a decision. The court does have to divorce the parties. So at the end of the whole thing, there is a decree that the judge stamps. But ideally, it really is just that. It's the parties have come up with how they want to divide up their stuff. The parties have come up with how they want to parent their kids. And the judge ultimately divorces them pursuant to what they've already reached agreement on. So usually we're just trying to help the parties reach agreement. I always tell my clients, I'm just the lawyer. I don't have any power. I can't make anybody do anything. There are only two ways things get done in this process. One of them is consensus of the parties, and the other one is court order. And court orders are hard to get. They're expensive. They take a lot of time. They can be really risky. So those of us that are practicing family law work really hard to help our clients reach consensus, because consensus is how we, again, get that party from point A to point B. And the way that we drive that consensus is we try to help our clients understand, what would the court do if you don't reach consensus, right? So since the only other way to get things done is have the judge ultimately make the decision, we use that as the guide. So I often say to clients, we're going to talk about the hill, the battle hill, right? Is this a hill that you want to plant your flag on? Or is this a hill that you're going to end up dying on? Because we use what the court would do to help guide the parties in terms of being able to come to the middle and reach consensus. So looking to get from point A to point B, and we're going to try to do it by reaching consensus, because it's one of the only two ways that we can get things done. And the first thing we're going to try to reach consensus on is how to divide up the stuff. So again, if you can't reach consensus, because that's how we kind of help people guide down the path, is if you can't reach consensus, then the court is tasked with dividing the marital estate fairly and equitably. So we are not a community property state. Montana is what's called a fair and equitable state. And of course, the first question the clients always asks is, well, what is that? What is fair and equitable? It's exactly what it sounds like. It's what's fair. It's what the judge thinks is fair. Sometimes what's fair is equal. Sometimes what's fair is unequal. It's not the same. And so it really depends on the situation of the parties and the context in which they're presenting themselves to the court. So, but the court is tasked with dividing things fairly and equitably based on when the parties show up. So an important part of that kind of fair and equitable analysis is that it's prospective and not retrospective. Everybody's had some come in their office and say, well, back in 1993, I was the one that bought all the groceries, so I want to be reimbursed for that when we divide all this stuff up. And that is not how it works. The court takes you on the day that you show up, and they try to divide things fairly and equitably moving forward, not backwards. The assumption, whether it's true or not, is that up until that point where you decide to be divorced, the decisions that you've made as a married couple are decisions made by consenting adults that are capable of making decisions. And so even though now the decision you made in 1993 to buy all the groceries doesn't seem like a good one, it was a decision that you were capable of making then, and we're not going to undo it and kind of do some sort of true up here now that we've reached a point where we aren't happy with those past decisions. So, and generally speaking, that's the reason that is, right, is because it's fair. When people are married, they're making decisions for the good of the order, in theory, not necessarily for the good of one individual or the other. And so we don't undo those and try to sort out what would have been best for what individual during the course of the marriage. Again, it's just instead what we're going to do to be fair and equitable moving forward. And so we're going to divide fairly and equitably the marital estate. Right. So the next question is, so what's the marital estate? And the marital estate is all the debts and assets that the parties have accrued during the course of the marriage. So it can be a lot or it can be a little. If you've got a couple that comes in that wants to get divorced, it's their first and only marriage and they've been married for 40 years. Most likely just about everything they've got falls within that marital estate because they've either acquired it or become obligated to pay it while they were married. Doesn't necessarily matter whose name it's in. It doesn't matter that the retirement was earned by one party in their course of employment, or that, you know, all the curtains were sewn by another party during their time working on the house. It generally, it's like a Christmas tree. The second you bring it through your front door, it belongs to everybody in your family. And so everyone has a marital interest in property that's comprised in of the marital estate, even if they don't necessarily have a name on that interest or a titled interest. So we look at the debts and assets that have been accrued during the course of the marriage. There are things that are not marital estate, premarital assets, if they can be very well distinguished from marital assets, or premarital debts can be considered non-marital. Things that people inherit can be considered non-marital, or things that people are given as gifts can be considered non-marital. And when I say can be considered, and that's because that there are situations in which even if you did receive a gift, or even if you did receive an inheritance, or even if you did have premarital property, you can mix it up in amongst the marital property enough that it kind of loses its non-marital characterization and becomes marital property, and that's called commingling. And the easiest way that I can describe kind of how that part works when I have clients come in is I tell them, you know, when you get married, one of you is a yellow crayon and one of you is a blue crayon, and you jump in a hot pot on a stove together, right? And so if after just a little bit of time, you tell me, I want out, get me out of here, you can look in the pan and you can see what's yellow and what's blue, and you can kind of pull them apart and keep them back to their own colors, right? But after you've been in that hot pot for a long time, you aren't solid anymore and you aren't yellow and blue. You're just a liquid pot of green. And so really there's no way to kind of pull out what used to be yellow or what used to be blue. The only way to do it is pour some green liquid in one cup and pour some green liquid in the other. So the more you mix things into that pot, the more you put yellow stuff into the pot or blue stuff into the pot, the more likely it is that it's going to be divided by the court as marital. But to be held out would be like if you received if your dad gave you a gun when you were 10, and then after you got married, you still had this gun at the time of your divorce. That wouldn't be something that would be subject to division. You would get to keep your gun. It would be a gift and it would be considered non-marital. And the court wouldn't decide how to divide the marital estate based on the fact that you got to keep the gun. It's just yours. Oh, Brenda's has her hand in the air.
One question is whether or not, one question is if people think something is a non-marital asset or a inherited asset, does that mean they don't have to tell the other side they have it? Can it be kept secret, or do they have to disclose it anyway?
That's a good question, and they have to disclose it anyway. So basically everything that you have, and we'll get there in a second in terms of the kind of the nuts and bolts of how we go about dividing up this stuff, but everything that you have and everything that you owe has to be disclosed to the other party as part of this process. And one of the reasons is, even though the gun that you got from your dad for Christmas, or the money that you inherited from your grandmother, or the trust that your uncle set up for you when you were a small child that you still have, even those things are non-marital, the court does get to consider that they exist when they figure out how to fairly divide what is marital. So, I mean, the examples, like if you and your husband have a house that's worth $100,000 and that's the only thing you have, and you also have a trust from your childhood that's worth $60 million. Well, the court might think that maybe then your husband ought to get most of the $100,000 house, because you've got this huge asset over on the side there that's not subject to division. So, and that's the Funk versus Funk case, where it allows the court to kind of look from that 30,000-foot view and consider the things that they're not even allowed to divide in terms of how to fairly parcel out the stuff they are allowed to divide. And so, yes, you do have to disclose it all. We have a form called the Declaration of Disclosure, and that's how we divide stuff. The first thing we do in dividing is we got to identify the universe before we can divide it. And we do that with this form. Each party fills out a declaration of disclosure, and they put on there everything they have and everything they owe. And we even have parts on ours where it says inherited stuff, gifted property, premarital property, specifically designed to let that party know that those are things that they need to put on the form as well. And after they've filled out that form, at least once and sometimes twice in the process, depending on how long it takes, we trade forms. So the other side gets our declaration of disclosure, and we get the other side's declaration of disclosure. And that's so that when parties are trying to figure out how they divide things up fairly, everybody knows what everybody's got. It is just a civil process. It's not criminal law. It's nobody's going to jail. But so it does trust that when people say they're telling the truth, they're telling the truth. But in order, they have to sign that declaration declaring they're telling the truth. So if people are willing to hide assets or lie about things, they have to break the law in order to do it. So that's kind of the quality control check. The court knows that when the parties say, here, judge, we've reached this agreement on how to divide up our things, the court can see that both parties have exchanged that form. And so as best as this process is able to police, the parties have exchanged with each other everything that there is, and they know what they're agreeing to, as opposed to deciding on how to divide stuff when they don't know all the things that are out there. And we try real hard in our process to make things as efficient as possible. You kind of try to gauge what scaffolding each set of party needs, right? So like some parties can sit around the kitchen table and talk about this stuff, and they know all of it, right? They both know everything the other one has. Some parties need temporary order protections and third-party applications to communicate. Or you get a couple where one person was the money person and the other person has no idea what they have or what they owe. So once we do that initial exchange of the disclosures, usually the lawyers try to be pretty cooperative with each other and say, hey, I saw in the declaration of disclosure, he listed an account. She didn't know about that account. Can you get me an up-to-date statement so I could see the balance? And, we try to work with each other so that, again, the parties have enough information about what that universe is that they can enter into discussions about how to fairly divide that universe. So yeah, we do that through the declaration of disclosure. And on that declaration, in addition to listing all of the assets and debts, the parties list what they think the values are. We also disclose on that declaration of disclosure monthly expenses. So if we have a case that involves spousal support, which I'll talk about in a hot second, then we have an idea of what each party has in terms of their individual expenses, living expenses outside of the marriage. How much does it cost for each party to continue their life, even though they're no longer living as a married couple? We use, there's different ways that you can value things in our process. Again, we try to err on the side of efficiency. Both parties are paying lawyers, and even though they're going to go their separate ways, at least when they initially hire the lawyers, they're still a family, and all that water or that money is coming out of the same bathtub. And so I think all of us in Helena try really hard to be cooperative and make sure that we're being as efficient as possible. If our parties just agree on a value, we let them. So if husband and wife say, hey, we've got this house and we don't really know what it's worth, but we're going to just agree that it's worth $400,000. then we let them agree to that. And we kind of negotiate how to divide up the other debts and assets based on that agreed upon value. With real estate, obviously, if you don't agree, you can get a CMA or you can get an appraisal. And then, usually we kind of, if we have two different appraisals, we average them or something like that. But we have some ways that we can agree upon or assign values to assets in the event that the values are important in terms of dividing up, or the parties can't agree on how to divide up with the values. Similarly with retirement accounts, is always something it seems to be that surprises people. That's part of the marital estate and it's part of what gets divided. I think people feel really personal and have personal ownership of their retirement accounts because they've individually earned them in the course of their employment. But if you've earned that retirement account money while you were married, it's a marital asset and it's going to be part of what's divided. And those are valued by if they're a defined benefit, then they can be valued differently. If they're a defined contribution, then they're just their balance. So like a 401k, its balance is its balance. If it's a pension, which is a defined benefit, then we have to do kind of a value calculation. So Brenda, I saw you had your hand raised there.
Yes, we have a question in the chat from Kristen. She has asked, do plans like Medishare qualify as health insurance coverage for children in the process of divorce?
Well, so anything can, yeah, I mean, I guess I can't speak specifically to Medishare, and thank you, Kristen, for your question. But what I can say is that the process of divorce and establishing a parenting plan, it's one of the things that's absolutely required is the parents are required to procure insurance for the kids. If the court doesn't order it, the administrative body of Child Support Services Division will order it. But the parents are required to procure insurance. So if one of the parties has access to a certain type of insurance or like Healthy Montana Kids, then that can certainly be the insurance that the children have. But usually the way that a parenting plan is worded is we kind of designate which party is going to cover the kiddo. And we, or kiddos, we usually choose that based on which insurance policy is more reasonable in terms of premiums or which insurance policy has better coverage if we have a choice. And that parent then is required to procure that insurance for the child so long as it's reasonable in terms of cost. And reasonable cost is something that's defined by the rules in terms of a particular percentage of a net income of a party. So if your insurance premium suddenly goes skyrocketing through the roof, you're not still required to continue to use that policy for your kids. And then usually what the language will say is, and if that policy becomes unavailable or unreasonable, then the parties have to work together to procure some other form of insurance for the kids. So, I mean, I'm not overly familiar with Medishare, but I have seen some religious-based organizations that have kind of a insurance pool, and I've seen that used in the parenting plan as being the designated form of insurance for the kids. So I'm not sure if that answers your question or not. If not, just throw something in the chat for Brenda and I'll try again. But thank you for asking the question. So in terms of that, again, with the property settlement and agreement, we're just trying to see if we can divide up the stuff, right? So after we've done the declarations where we say everything that we have and we assess what all the values are, then we just try to sit down and see if we can hammer something out. You don't have to divide up each asset individually. So you don't have to sell the red car and sell the blue car and then divide the proceeds. You can say, hey, Brenda, you get to keep the red car and Sarah, you get to keep the blue car. And if they're about the same value, great. If Brenda thinks my blue car is worth way more than her red car, well, then I owe her $1,000 to even it out or whatever. But then we start kind of trying to put things, I always call it put things in the buckets, right? Once we know what's in the universe and what generally those things are valued, then we start assigning buckets. So is this something party A wants in their bucket? Is this something party B wants in their bucket? And we try to figure out, are there things that either both parties want in their bucket or that neither party wants in their bucket? And if so, how are we going to deal with those things? And then once we've kind of got the things in the buckets and or identified in terms of we both want them or we both don't, then we start trying to figure out how much are each of the buckets worth? And if one party's bucket's worth more than another party's buckets, then we figure out how to even that out, either by trading asset or volunteering to take on additional debt or a cash payment. But ideally, we come up with an arrangement that's fair based on the parties. So if you have parties that they've been married 10 years, they both have the same level of education, they both work outside the home, they're both healthy, they both earn pretty similar incomes. Usually what's fair is a 50-50 division of the marital estate. If you've had parties that have been married for a really, really long time, and one party's always worked outside the home and one party's never worked outside the home, or one party's healthy and one party is not, those things can change whether or not 50-50 is what's fair, or 60-40 is what's fair, or 70-30 is what's fair. We just try to figure out kind of what we think it's likely the judge might do to help, again, drive getting folks across the finish line and reaching an agreement on how to divide up their stuff. So most of the time, in my experience anyway, I mean, you guys, the judges certainly can speak for themselves and do, but the judges don't want to divide up other parties' stuff. I mean, these parties that we're representing as husband and wife, the judges don't know them. I always tell my clients, if you ask the judge to divide up your stuff for you, it's like going down on the street right now, grabbing somebody and saying, "Hey, what should I do with my money?" I mean, that's just not how most people want the things that they've worked so hard for to be handled. And so the judges don't want to divide it up. Parties don't want judges to divide it up. So usually if the parties can reach an agreement, that's okay with the judge. In my practice anyway, I've never seen a judge reject a property settlement agreement that the parties reached, because typically the parties are the right people to decide what they should do with their debts and their assets. So we try to do that. We come up with that contract, that property settlement agreement, and then we file it with the court and we say, "Hey, judge, please divorce the parties pursuant to this agreement and make this contract that they've entered into between them a court order." And that's how the property settlement agreement kind of comes to be and how the stuff ends up getting divided. And sometimes, depending again on the context, usually in the situation where you've got a relatively long-term marriage, and you have financial situations that are pretty different for the parties. So like I described, maybe somebody that's worked outside the home for the entirety of the marriage, and then another party that hasn't worked outside the home, that's been a stay-at-home parent or a stay-at-home spouse for the entirety of the marriage. Or if you have a party that is healthy and working versus a party that's disabled and unable to work moving forward or has limited ability to work. Sometimes dividing up the marital estate isn't enough. Either there's not enough of the marital estate to divide to make it so that everybody can go off on their own and not be required to seek state assistance or other assistance, or the parties don't want to divide up the marital estate in a way that provides enough for that other party that maybe is disabled or that has some catching up to do in terms of returning to the workforce. And when that happens, we consider what's called maintenance, or spousal support, alimony. There's all sorts of words that it's called. Generally in Montana, maintenance is not favored. There's a statute that talks about maintenance, or a law that talks about maintenance, and there's some pretty specific qualifications that a party has to meet in order to have their case be what's called a maintenance case. But if you meet those qualifications, you can additionally seek from the judge, in addition to a division of debts and assets, a decision on an amount of spousal support and a length of time for that spousal support. Typically here, again, we're a fair and equitable state. If you meet the qualifications of the statute, then you just get to show up and pitch what you think is fair in terms of, or appropriate or needed for maintenance. We typically try to have maintenance be tied to something that's happening in reality, right? So if you've got a stay-at-home parent and the last child leaves the home to go to college or becomes an 18-year-old in 4 years, well, then 4 years seems like a reasonable amount of time to be talking about spousal support. Or if somebody's going to go back to school and they need 3 years to attain their degree that they're going to go back to school for, or their certification, then maybe maintenance is 3 years. Somebody has an additional mortgage payment or loan payment that's another year, maybe that maintenance lasts 12 months. But we tend to try to tie it to some sort of real thing that's happening for the parties that makes that spousal support, that extra spousal support, in addition to the division of the debts and assets, necessary and makes sense in terms of how we're going to fairly divide folks kind of moving forward. So again, it tends to be that maintenance is only talked about when there's just not enough in the pot to divide up moving forward, or the parties are so dissimilarly situated that it's really the only way to kind of even things out for folks to head off on their own way. So that's kind of the division of debts and assets in a nutshell, which is of course the one of the two things that has to be divided when it comes to getting a divorce. So does anybody have any questions or anything about debts and assets and that process of dividing them? That seems like it would be a good time to ask now. And if not, I can move on to parenting.
So far, I'm not seeing any questions. Oh, here comes one.
Okay.
We have an attendee says, what if one party racks up a lots of debt during the separation period, but prior to the final decision of divorce?
And so that's a great question. And I would say that that period of time between getting from A to B, right? I always call limbo. And limbo's hard because there are some rules about the way it works in limbo, but there aren't a ton of rules that cover everything. I mean, you're still married. And so people can do what married people do unless, of course, there's been a filing. And if there's a filing, there are some rules associated with what you can do. But generally speaking, again, the court gets to do what's fair. So if you can show up to the court and say, Judge, I filed for dissolution on January 1st. And now it's June 1st because this was the first time that you had an opening on your calendar for me to come up and tell my story and have you decide what to do because we can't reach agreement. And in that 6 months, my soon-to-be ex-spouse has gone to Disney World 17 times and did it behind my back, did it without me knowing, wasn't supposed to happen. Now am I on the hook for half of the credit card charges for all those Disney trips? And I think that what I would tell my client in that situation is, again, I'm not the judge, so I can't make any promises, but I would think that the judge would say, well, that doesn't sound very fair. Right. And that's what the judge gets to do in this instance is they get to do what's fair and what's equitable. And so it doesn't seem very fair if you've racked up those charges during the course of time that you've been separated, then most likely the party that's done them, especially if it's done without the knowledge and consent of the other party, is going to be responsible for them. Now, in high contrast, I have people that show up and say, my spouse went to Disney World 17 times while we were married. And I didn't realize that they weren't paying for it as they went all along. And I went too, and it was great. But I don't think I should have to be responsible for that because I didn't know. In that case, not so much. So ignorance is not a defense, not in family law, nor in very many other areas of the law. And so the fact that that was happening while you were married and you were enjoying the benefits of that kind of obligation or incurrence of that debt, it's going to be really hard to argue to the judge that you shouldn't have to have anything to do with it. So in the course of separation, I think oftentimes there's a good fairness argument that will carry the day. But if you're doing it before you separated and you had any knowledge of it, you're probably going to be on the hook for it. Yes, another question?
We have 4 more. I will, and I don't know if Sarah, if you can pull up the chat, but the next question is one that says, what if the other party lied on the disclosure? Is there any recourse?
So that's tough, right? I mean, the disclosures, this is a civil process, right? We don't have the court system doesn't have forensic accountants standing by to do the deep dive into everybody's finances or everybody's answers. I mean, certainly can somebody hide the Renoir in the basement or sell the really valuable elk mount to their brother for $1 and then buy it back after the divorce? Yep, they can. If they get caught, then they can get in trouble because they've broken the law. They've perjured themselves and they violated the process in terms of what they're supposed to do for the declarations of disclosure. There is some language in the statute that if you find out within a certain period of time that happened, basically it's fraud, right? that you can seek remedy with the court. You can say, hey, judge, I wouldn't have agreed to this if I would have known about this account or this transaction or this asset. And I didn't, and they knew about it and they didn't tell me. Then there is a remedy. The court can undo and redo things. But I often tell people, I mean, I have a lot of clients that are convinced that the other side is lying. And I mean, they know the other side better than me. So that's hard to say that they're wrong. But most of the time, the cost of ferreting out whether or not somebody's lying is far, far greater than the value of what they're lying about, at least in kind of the day-to-day practice of law. But so the answer is there a remedy? Yep. Is it a good one? Nope. Which is often, as Brenda will, I think, agree with me on, what we are faced with telling our clients.
Yeah, I think that one of the, there is a hammer clause in statute, or I call it the hammer clause, that there are certain assets, if there's a fraudulent failure to disclose, sometimes the court can award an asset to the other party. But I think Sarah's absolutely right. You've got to look at the value of the asset, because sometimes it's just not worth it. It's a Charlie Russell original, yes. The Charlie Russell calendar, probably not. So that would be what I would say to that. We have 3 more questions, and the next one is just a quick. Can you see those up there? You want to go ahead and take the next one?
So the first one I see is 401k liquidation taking the hit. So we have a process with dividing retirement accounts like 401ks. It's called a qualified domestic relations order, and it allows for one party to transfer a portion of an account, like a 401k, a qualified account, to the other party, to their qualified account, without taking any of the tax hit. Now, if you pull money out that you're going to use, then you take the hit, right? But if you just, let's say you have $100,000 in your 401k, and in the division of debts and assets, you decide that 50,000 of it is going to go to your soon-to-be ex-spouse, you can roll from your 401k to an account that she opens, that $50,000 via the qualified domestic relations order without feeling the tax hit. They're kind of a pain in the butt, but they are a tool that we use every day. Because lots of times the retirement assets are a huge part of the marital estate. They have to be divided in order to kind of have things be fair and equitable. And of course, nobody wants to take the tax hit. So we do have a tool that we can use to divide those accounts without the tax hit happening. And that's about as much tax advice as I'm willing to give. Let's see. How are student loans handled in the division of debt? It depends. It depends on the situation of the parties always. If a student loan was incurred during the course of the marriage, it's considered a marital debt. But again, we kind of look at the situation of the parties when we figure out, so who gets to take it. I think in my practice, I've seen that the argument has been successful that the person that gets the benefit of the education is the person that has to bear the loan. But most student loans there's a portion of them that are tuition based, right? And then a portion of them are for living expenses, or can be. And so what I've seen happen is that the tuition portion of the loan gets to just go with the person that gets the education. But to the extent that the family used money from the student loan disbursement for things like food or computers or those kind of things, that's considered more of a family debt, and that's going to be divided between the two parties. So that's usually how that goes in terms of student loans. In terms of, does each spouse have a separate lawyer? Ideally, yes. I don't ever represent both spouses. That's, as far as my interpretation of the rules of ethics, that's a no-no, because you're not supposed to represent people that have adverse interests. And I don't know how you can describe two people that are getting divorced as anything other than having adverse interests. So I never represent both, ever, ever, ever. Sometimes I represent one and the other chooses not to have representation, and they can do that. And that's fine. And it happens quite frequently. Every time I see the unrepresented party, the party that's choosing to represent themselves, every time I see the whites of their eyes, I say, I'm her lawyer. I'm not your lawyer. I can answer questions for you. You can talk to me. We can negotiate as if you are counsel. But I need you to remember, I am advocating for her and just her. And if you want somebody to advocate for you, You can go find somebody to do that, but it can't be me. And so that's, but ideally, yes, both parties each have their own lawyer to represent them. Let's see, if one party has an attorney and the other party is representing themselves, does the trial resort to an informal IDRT or a traditional trial? Again, it depends. See, if any of you are listening here for the first time, you know how we have our job security. Everything just depends on the situation. So we
And I
do
think
have.
and I do
Oh,
want
go
to
ahead,
interrupt,
Brenda.
you know, we might want to explain what an IDRT is
Yep.
too, because that's a new thing a lot of people don't know about.
Yep. So the informal, it's an informal domestic relations trial is, it's kind of, I think it's still a pilot. If not, it's newly not a pilot, program that the judiciary has looked into developing that allows for a relaxed trial is the best way I can come up with it. One that is not necessarily conducted pursuant to the rules of civil procedure or the rules of evidence, when both parties are unrepresented. That's what the design was. But it does apply, actually, the way that it's written in Lewis and Clark County is the informal domestic relations trial is the default setting unless you opt out. So you can have it if you want it. Anybody can. Even if you have lawyers, you can. But if you don't want it, you don't have to have it. So if you're both unrepresented and you want a formal trial, you can opt out of the informal domestic relations process. If you have one lawyer and the other party isn't represented, either party can opt out. And then again, obviously with both lawyers, you can both opt out. So it just depends on what the parties want to do. But if two parties are unrepresented and they don't opt out, then they will have an informal domestic relations trial, which just allows the judge to ask questions as opposed to all the evidence having to be presented pursuant to the rules of evidence. Does anybody have any other kind of property sort of debts and assets questions? All right, well, I will speedily move on to parenting. So the other thing, like I mentioned at the beginning of the webinar, the two things that we divide up when we get divorced, debts and assets stuff, right? Debts and assets, and the parenting time with our kids. So when we're figuring out parenting, if you're going to be married, if you're not going to be married anymore and you have kiddos, you got to have a parenting plan. So the parenting plans do several things. Primarily, they determine residential schedule. So who the kids are with and when. Not parental rights, just residential schedule. Where are they sleeping at night? Health insurance, like we talked about briefly already, child support. And then I call it other stuff, which is how do we reach agreements, right? What things do we're going to agree our kids aren't going to watch R-rated movies till they're 13, or if you're going to take the kid out of the state of Montana, you'll tell the other party, or, you know, we're not going to introduce the kids to a new significant other for 6 months, or whatever it is, that other things that the parties want to have in the parenting plan that kind of govern how they're going to co-parent their kiddos moving forward as a divorced couple. A parenting plan is a limiting document. So prior to having a parenting plan, both parents have the right to be with their kids 100% of the time. So, and they have 100% of parental rights. A parenting plan doesn't limit your parental rights, but it does limit the residential schedule. I mean, when you agree to a residential schedule, you're actually not agreeing that I get my kid every other week. You're actually agreeing I don't get my kid every other week, right? I'm agreeing to this other residential schedule other than the right to be with my kid all the time. So the parenting plan limits what each of the parties get to do in terms of carrying out kind of the duties of parenting. Both parents are still 100% parents of their kids under a parenting plan. This is not a termination of parental rights. That's not something we do frequently in our process. It does happen, but not very frequently. Here it's just both parents have 100% right to be parents. Everybody gets access to the kids' records, medical and school. Everybody can go to their volleyball games. Everybody's, you know, on the hook to make sure that they have health insurance or that they're taken care of and they're fed. But we just are talking about where they're sleeping at night and who gets even year spring break and who gets odd. So parenting plans are they just are dividing up how we're going to co-parent. They don't assign rights or take away rights. Again, just like with property, the idea is for the parents to figure this out, right? The two best people to make decisions about their kids are the parents. I always tell my parent clients, If you want to know what the judge is going to know about your parenting case, take a black sheet, throw it over a lamp, and then poke a pin in it. And the amount of light that gets through is how much the judge is going to learn about your family and your kiddo. And nobody wants somebody with that little information having to make decisions about the kid. And I would tell you that, again, I don't want to speak for the judges, but I think if you polled them, they would tell you that one of the worst things they have to do is make parenting decisions for people who should be able to make them on their own. It can be really, really hard, and you're making decisions about a family you don't know. So generally speaking, we try really hard to help the parties reach consensus on what that parenting looks like by, again, using as a guide, what do we think the court would do if we had to go ask the judge to do this for us? The standard, like I said, for property, the standard for the judge is what's fair and equitable, right? For parenting, it's what's in the best interest of the child. And that's defined by law. You'll hear parenting or attorneys that practice family law that do parenting work, quote 212, and that's Montana Code Annotated 44-212, which is the best interest of the child statute. And it lists out all the different things that the judge is supposed to consider in terms of what's in a child's best interests. Generally speaking, what's in a kid's best interest is to spend as much time with both their parents as they can. And so that's the thing that we try to remind people in terms of how we reach consensus on what's this parenting plan going to look like. The other things that the court considers from that statute, the wishes of the parents, siblings, how the kids are adjusted to their home, to their school, to their community, to the other members of their family that may not live in the home, but maybe live in the community. The mental and physical health of all that are involved, the parents, the kids, the other members of the family, whether or not there's been past physical abuse, if there's any ongoing substance abuse, if there's continuity and stability for the kiddo, and then overall the developmental needs of the child. So there's all sorts of things that the court is required to consider in terms of what's in a kid's best interest if the parties can't figure that out on their own. But again, we always try to advocate that the parties try to figure it out on their own. For that same reason, you don't go down in the street and tap somebody in the shoulder and ask them to decide what you should do with your kid. And so usually we try really hard to help the parties get there on their own, because parents are the ones that should be making decisions for their kid. At least that's been my experience practicing law in this area. So residential schedule is the first thing that's kind of the big ticket item in a parenting plan. And that's just where the kiddos sleep, right? We call it residential schedule or parenting time now. There really isn't much a thing of full custody anymore, unless, again, the states come in and said, one parent isn't safe, then the other parent would have full custody. But otherwise, everybody has custody. It's joint custody. It's just a matter of what's the schedule, what's the parenting time, what's the schedule. And the schedules that parties agree to vary based on their location, based on the ages of the kids, based on what the parties want. There's kind of 50-50, which is each parent has half the time, half of the parenting time. If there's 100% of parenting time available with the kid, each parent gets 50%. That can look like week on, week off residential schedule. It can look like, we call it a rolling 2-2-3. So 2 days with one parent, 2 days with another parent, 3 days with the other parent, and then you roll. A standing 2-2-3 where mom always has Monday, Tuesday, dad always has Wednesday, Thursday, and we roll Friday, Saturday, Sunday. Or it can be a more traditional, less than 50-50 arrangement, goes to school from one parent's house and is with the other parent every other weekend. And then the majority of the summer, sometimes that's a schedule that you have to consider if the parties don't live nearby one another. But again, ideally what we're trying to do is make it so that both parties get to spend as much time with the kids as they can. At what age, I'm just reading a question now. At what age did the decision of the housing schedule switch from the parents to the kids? So in theory, never. Okay, so what the child wants becomes something that the court can consider as part of that list that I talked about when the child is 14. So before 14, most of the time, it doesn't even make the list. And then after 14, it's one of the things that's on the list, but it's not dispositive. We don't just let the kid make the decision. So they're a minor. They don't get to decide a lot of things. We don't just let them decide. I will tell you that generally speaking, though, good luck making a 16-year-old do something a 16-year-old don't want to do, right? So the law is that we always consider the best interest of the child. We do take what they want into consideration as they get older. The reality is that most of the time children are in their upper teens, it's really hard to make them do something other than what they want to do. So there's kind of the law, and then there's kind of teen reality. And anybody that's parented a teenager, I think, can understand that piece of it. So hopefully that answered the question.
I was thinking
Brenda,
that
did
this
you want
might
to
be a
weigh
good
into?
time. Yeah, this might be a good time to jump in about the role. Well, two things. First, of course, is it doesn't mean that a 10-year-old kid has no input, because the best interest includes whatever the child expresses. It's just that the judge weighs it differently when they're younger. But this is also a good time to talk about the role of a guardian ad litem, because that's sometimes what also can be a voice for the children in these cases. And so
Yeah,
maybe you want to take a couple seconds on that.
Sure. Guardian ad litem is exactly what Brenda just described, is that they're a third party professional that is basically assigned to advocate for what's in the best interest of the child. And they get to speak to what's in the best interest of the child. That's not very many people get to do that. Counselors don't get to do that. Guardian ad litems are one of the few people that get to actually make an statement of opinion to the judge about what they think is in the child's best interest. And guardian ad litems are almost always used. Brenda, you would know this better than me, in dependent neglect or youth in need of care cases. But in our little civil world, are used where the parents we are just at 6s and 7s, right? So like a move case, right? Where one party wants to live in Montana and one party wants to live in California, and they both want the kid to be primarily with them. And there's just not a great way to be a middle ground, right? And so in that case, sometimes both lawyers will agree to appoint a guardian ad litem, and that person gets to come in and do an investigation. They get to talk to doctors and teachers and the parents and the kid and the family and everybody involved, and then they get to make a recommendation about what they think is in the children's best interest. So they serve as another tool in our process, again, to help parties come to an agreement. Usually whatever the guardian says they think is in the kid's best interest, there's a pretty good chance the judge will agree with them, because the guardian gets to know way more than the judges ever will. So oftentimes that helps guide parties. Like once the guardian's made a decision, then, oh, well, maybe I'm going to need to come in a little bit closer to the middle, or those kind of things. So, but they serve as a voice for the child, and can speak to the court in a way that not very many other participants in the process can speak to the court. Another thing that's considered in a parenting plan, one of the other big ticket items, and I'm just going to try to make it fast so that if anybody has any questions, we can get those in. Our insurance, we talked a little bit about that. All parenting plans have to address health insurance for the kiddos. And then child support, which probably could be a whole nother hour-long webinar that I'm not even positive I should be the one to give, because it feels like every time I think I've got a handle on it, it changes. But it can be something that the parties kind of decide on their own, or it can be something that you can use the state to assist you with. There's an algorithm that kind of can spit out what child support should be based on parties' incomes and the residential schedule for the kids and who pays insurance, and plug the numbers in and it spits a number out, trying to make what's always been a very subjective process into as objective as it can be. And so we definitely use that tool in our world when we're figuring out what child support is, or if we have parties that need some help in figuring out what child support is. And then things like I mentioned in the parenting plan, things like who has spring break and what are we doing on summer vacation, and how are we going to handle when you're going to be gone, and who can babysit, and all those different things. We try to think of ways to tie break points of dispute in the future in parenting plans. And it's hard. It is not a perfect process. I mean, people get divorced and have a parenting plan when their kid is 4, and it's still in effect when they're 14, right? So it's hard to anticipate every possible place where parties might disagree. But ideally, we come up with a plan that if the parties can't agree, then they can look at the parenting plan and get an answer. And so they don't have to go run into the judge every time they have a parenting dispute. And again, we try to reach something that they agree to. And if they do, then the court will order that as part of their divorce. So I see there's a question, a scenario. Parent one provides a clean, safe living environment within their school district, in this case, an apartment. Parent two has a house bigger than the apartment and the kids prefer to live there. All three kids are teenagers. Is there any recourse for parent one to have the kids for an equal amount of residential time? You know, again, I would say that kind of falls into the category of what I just talked about a minute ago, in that, I mean, is there a parenting plan? Would the court say, hey, yeah, that each parent should get to have equal time? There's not a bigger house doesn't necessarily mean the court would say you get more parenting time. In fact, not at all usually. But if you have teenagers, it's hard to make them do what they don't want to do. So you can get a court order that says, yep, 50% time with each parent. But if your 16-year-old says, I ain't coming, mom, then it gets really hard to make that make them come, because you have to call the police, and people don't usually want to call the police on their own kids. So I would say from a legal perspective, yes, there is a solution to that. You can always, the courts are usually really good about making sure, again, that both parents get as much parenting time with their kiddos as they can. But once you get to have teenagers that have their own opinion and are starting to individuate, it does become much, much more difficult to have the teenager follow the plan. If the court's not your problem at that point, that's a problem outside of the purview of what we can fix as lawyers. So I've got about 5 minutes left. I kind of truncated parenting quite a bit in order to kind of get us here, so that if there were any other questions. Does anybody have any other questions for me that they can think of?
While we're waiting for questions, Sarah, can you discuss a little bit about when you've got parents that have never married and never married, never had a parenting plan, don't live together? What's just some standard basics that folks in that situation should think of?
Yeah, so like I said, that a parenting plan is a limiting document, right? Prior to having a parenting plan, and I'm talking about parenting right now. I mean, I guess there's some things for them to consider in terms of debts and assets as well, but if you've never been married and you have kids together, is that both parties have right to be with the kiddo 100% of the time until there's a document that says otherwise. So you always want to make sure that if you have any concerns about co-parenting that child with your fellow parent, or that parent could decide to take the child and head to California or Las Vegas or New York or Mexico or whatever without your knowledge, if there's no parenting plan in place, there's nothing that prohibits them from doing that. They're a parent and they have the right to be with their kid 100% of the time. So I think that parenting plans are really, really important to have for parties that are looking at that are not in a perfect co-parenting relationship. So you know, if you have any concerns about what might happen with your kid if you and the other party are no longer in a romantic relationship, I think it's really important to get a parenting plan. And I would say that actually, just like anything else, right? The best time to get a parenting plan is when everybody's on the same page. So you mean don't have to get married to protect your interests as a parent. You can just get a parenting plan. But it is something to consider. I mean, whenever I talk to somebody that has a child and doesn't have a plan, that's not married to the person that they parent with, I say you should have a plan. But I'm a lawyer, so it's not surprising that that's what I say.
And it looks like we have a question.
Sure. And is that we are grandparents, how do we get help with visitation? Also very, very tricky. So for the most part, grandparents' rights are derived from the parents, right? So the kind of general rule of thumb is you get visitation based on what the parents allow you to have. There are exceptions to that rule, but they have to be pretty unique circumstances. I am not a grandparents' rights expert. So definitely don't want to get out over my tips here. I would say grandparents do have some rights in certain unique circumstances. But generally speaking, if you have two very capable and appropriate parents that don't have limitations on their parenting time, those parents get to decide who their kids spend time with. And I don't know if Rick has any thoughts on that one either, but yeah, I think we have about 2 minutes left. I can probably do one more question if somebody has one more question. All right, well, then I'm not going to keep talking at 7:28. I'm going to feel like I wrapped that up pretty good. So if I think I'm not sure, but I'm sure our administrator, the State Bar, could put in the chat my business email address. If anybody has a question or thinks of a question, you're more than welcome to reach out to me. I can't promise you that I'll have an answer, but sometimes I can at least point you in the right direction. And definitely appreciate that you guys were willing to come on and listen tonight, and that you listened to our little Brenda's my little corner of the world for an hour. Appreciate your time and your attention. So thank you very much. And thank you, Brenda.
Yes, well, thank you, Sarah. Really appreciate you helping us out with the Citizens Law School. And
Yeah.
Jill, with the State Bar, I'm noticing we do have a recording light on the Zoom. So are these recordings available to folks afterwards? Is there any way that anybody who had to drop out early can pick this up and learn more?
Yes, so we are recording all of the Citizens Law School presentations, and we will be making them available on YouTube. It will take us probably about 2 weeks after each session before we can get them up.
All right, well, with that, I think we'll wrap up the program, and thank you everyone for joining us tonight, and hopefully we'll see you for the next week's program. And I believe that one is going to be on criminal law. So everything you ever wanted to know that's not what you see on TV. Thank you so much for coming.
Thanks, everybody. Have a good night.